a living trust. And a trust is an ancient legal document. It's been around for a long time. As a matter of fact, it started in Old England with something called the Statute of Uses way back in the 16th century. And a trust is merely another way to hold title to property. And you know, a living trust is really very simple to understand. What I want you to do is imagine that we've got a big container, a big box, a big bowl, if you will. And what we're going to do is we're going to take all of the assets that you own and we're going to change the title on those assets and deposit them in that big container, and the container we'll call the trust. And the trust now owns the assets. Now that we've got the trust created, it's now time to talk about the people that are associated with the trust. There are three positions associated with the administration of a trust. There's the people that actually create the trust. These people are called trustors. And the trustors are the people that actually make the bowl or the box, and they transfer their assets into the trust. Once we've established that there is a trust that's in existence and there are assets owned by the trust, we need now to identify the people that are going to manage the assets that are in the trust. These people are called trustees, and the trustees can do anything that they want with assets in a trust. They can buy, they can sell, they can trade, they can exchange, they can mortgage, they can encumber. They can do anything with the assets in the trust except for one thing. The trustees are not allowed to spend the money in the trust on themselves. The only people they're allowed to spend the money in a trust for are people that are known as beneficiaries. Now, you've heard that word before too, haven't you? A beneficiary is the person for whom the trust is set up. A beneficiary gets all the benefit from a trust. So a trustor creates the trust, transfers the assets into it. The trustees manage the property, make all of those business and financial decisions, and the beneficiaries reap all the rewards. Let's talk about now setting up Bill and Mary's living trust. Now, remember, the people who created the trust, what were they called? That's right, trustors. And who are the trustors of Bill and Mary's trust? That's right, Bill and Mary are the trustors. They actually created the trust. And remember, the people that managed assets in the trust, what do we call them? That's right, trustees. Trustees manage the property in the trust. And who are going to be the trustees of Bill and Mary's trust? Well, some of you may have said Bill and Mary, and you're absolutely right. And some of the rest of you may say, wait a minute, I thought if we had a trust, we had to have a bank or a savings and loan or a trust company be the trustees. Not true. They perform a valuable function for people who can't manage their own assets, but you don't need to have a bank be your trustees. Bill and Mary can be their own co-trustees. Well, then, who are the beneficiaries of Bill and Mary's trust? Well, some of you may already know the beneficiaries are also Bill and Mary. Some of you say, well, wait a minute. If Bill and Mary created this trust and they have no new tax liability, either property or income tax liability, and they can change the trust in any way they want, well, what can they do with the assets that are in the trust? Well, the answer is anything they want. There is nothing that Bill and Mary cannot do with the property in the trust. When they're the trustors, the trustees, and the beneficiaries, they can do anything. They can add new property to the trust. They can manage the property, buying and selling and trading and exchanging. They can spend all of the money in the trust because they're the beneficiaries of the trust. And since they have the power to revoke the trust, they can end it at any time without any consequences. And you might say, well, it sounds like Bill and Mary are in exactly the same position after they created the trust as they were before they created it. Well, then the question is, well, then why did we create this trust anyway? Well, the answer is, if Bill becomes disabled, if Bill can't manage his property because of a disability like Alzheimer's disease or Huntington's disease or a major stroke or illness, are we going to need to have a conservatorship like we did when Bill and Mary planned with a will? Well, the answer is no. There's no conservatorship because the trust itself says that either Bill or Mary, with one signature alone, can do business on behalf of the trust. So if Bill becomes disabled, Mary, with one signature alone, can sign on behalf of the trust. No conservatorship. We have just jerked the jurisdictional rug right out from under the probate court. There's no hearings, there's no attorney's fees, no accountancy fees, and the control of the assets is kept in the family. And if Mary becomes disabled, Bill can do it with one signature alone. So we've avoided a conservatorship. Now, remember what happened when Bill died, when he had a will? All of the assets owned by him on the date of death, well, they had to go through that legal proceeding called probate. Well, is there going to be any probate proceedings with this living trust? Well, the answer is no. there's no probate at all. That means there's no court hearings, and with no court hearings, there's no attorney's fees, there are no executor's fees, there are no filing fees in the court, there are no appraisal fees. And remember those bond premiums? Well, we do away with those as well. There's no time delay. That means that if Bill dies at 2 o'clock on a Friday afternoon, at 2:01, Mary, with one signature alone, carries on the operation of the trust. There's no public record. So we've avoided a conservatorship and we've avoided probate. Now we go to the evil called death taxes. Is there going to be any avoidance of death taxes when the first spouse dies? Well, yes, there is. You remember? When all of the property gets passed to a surviving spouse, we've got that thing called the unlimited marital deduction. And with the unlimited marital deduction, Bill can pass all of his estate to Mary, and there are no estate taxes. So we've avoided a conservatorship, probate, and estate taxes. But we're not done yet, because now Mary's the survivor, right? Bill's dead, and Mary's alone. But what if Mary becomes disabled? Are we going to need a conservatorship? No, we're not. Remember, we've named Susan, and she would be able to handle all of the assets in the trust with just one signature alone. We've just eliminated all of the conservatorship problems. Now, when Mary dies 10 years after Bill died, you remember all the assets owned by her on the date of death when she didn't have a trust? Well, it had to go through that legal proceeding. What was it called? Probate. Is there going to be any probate with this living trust? No, there will be no probate even on Mary's death. And ladies and gentlemen, if you understand this, you understand how a living trust, as of January the 1st, 1987, can pass $1.2 million absolutely tax-free to your heirs. And what we've done is we've avoided a probate, we've avoided death taxes up to $1.2 million, and we've avoided a conservatorship, both when the first spouse was alive and when the second spouse was alive. But the very best thing of all about a living trust is not the fact that you're avoiding taxes and fees and costs. The very best thing is that you are avoiding giving away control of your assets, giving away control of your estate to banks or savings and loans or trust companies. You're not giving it away to the court system or to the government, not turning over control to the legal profession. You keep control of your assets in your family where they belong. And some of you say, I don't even want to give it to my kids. I want to just give maybe the income to my children, and after they die, I want the principal to go to the grandchildren or the great-grandchildren. The trust allows you the distribution pattern that you choose. You can disinherit kids if you want, or you can leave them with unequal shares. It's up to you. The living trust is the most flexible estate planning document available today. It has been around for so many years and offers so many benefits. And then why do you say, has nobody heard about it? Well, I think the fault lies with my profession, the legal profession. And frankly, ladies and gentlemen, we haven't been telling our clients about the living trust. It's been around for years, but we've been telling you to get into wills. And why is that? Well, I'm afraid that there's a conflict of interest built right into the decision of whether to have a will or whether to have a trust. Because if the attorney counsels you to get a will, he's probably going to get the probate when you die. But if you seek out an attorney who advises you to create a living trust, you can avoid all the problems associated with a will. I want to thank you very much for allowing me to present these estate planning concepts. And I trust that this tape has opened your mind to a new way of planning your estate.